The Companies Act 1956. Today we are going to understand the definitions of four terms. First, company. Second, existing company. Third, private company. Fourth, public company. These definitions are available in section 3. Before going to section 3, let us understand how these four terms are referred in section 2. In section 2, all these four terms are referred as company means a company as defined in section 3, clause 10 of section 2. Clause 10 of section 2 says company means a company as defined in section 3. Clause 16 of section 2 says existing company means an existing company as defined in section 3. Clause 35 of section 2 says private company means a private company as defined in section 3. When it comes to public company, clause 37 of section 2 defines public company means a public company as defined in section 3. This is a very important section in the Companies Act 1956 where we can find definitions of very important terms: company, existing company, private company, and public company. Subsection 1 of section 3 says, in this act, unless the context otherwise requires, underline, unless the context otherwise requires, the expressions company, existing company, private company, and public company shall, subject to the provisions of subsection 2, have the meaning specified below. Subject to the provisions of subsection 2, we will understand the provisions available in subsection 2 after some time. Subject to the provisions of subsection 2, unless the context otherwise requires, in this act the expressions company, existing company, private company, and public company have meanings specified as below. Clause 1 of subsection 1 of section 3 says, company means a company formed and registered under this act, or an existing company as defined in clause 2. So here two expressions are available in the definition of company. It says both. Company means a company formed and registered under this act, underline, formed and registered under this act. Second expression is company means an existing company as defined in clause 2. Means companies existing before the Companies Act 1956 which were formed and registered under the previous companies laws. Again, company means a company formed and registered under this act, or an existing company as defined in clause 2. Let us go to clause 2 after some time. Before going to it, let us understand something more. Clause 1 of subsection 1 of section 3. Company means a company formed and registered under this act. What about a foreign company? Really, what about this? When we find the word company with holding company and subsidiary company, the word company is wider in its scope and includes a foreign body corporate. Again, when we find the word company with holding company and subsidiary company, the word company is wider in its scope and includes a foreign body corporate. Now shall we jump to section 4, where we can understand something about body corporate. Subsection 5 of section 4 says, the expression company includes any body corporate. Underline. The expression company includes any body corporate in subsection 5 of section 4. Here, in clause 1 of subsection 1 of section 3, it says company means a company formed and registered under this act or an existing company as defined in clause 2. We are not able to find the term body corporate and foreign companies. For that we were trying to understand what about a foreign company. When we find the word company with holding company and subsidiary company, the word company, underline, the word company is wider in scope and includes a foreign body corporate. When we go to subsection 5 of section 4, we can understand the expression company includes any body corporate. Underline. The expression company includes any body corporate. Let us recollect something about the term body corporate, how it is defined in the Companies Act 1956. Clause 7 of section 2 says the term body corporate or the term corporation includes a company incorporated outside India. Includes a company incorporated outside India. Body corporate or corporation includes a company incorporated outside India, but doesn't include what? There are 3 points. It doesn't include, means this definition doesn't include a corporation soul. Number 1. It doesn't include a corporation soul. Second, it doesn't include a cooperative society registered under any law relating to cooperative societies. And third, it doesn't include any other body corporate which the central government may by notification in the official gazette specify in this BR. So from this definition, we can understand what is the term body corporate stands for. The body corporate, the term corporation, includes a company incorporated outside India. You may get doubt. What about the companies incorporated in India? Is not body corporate. That we may understand in this section itself. Let us repeat how company term is defined. A company means a company formed and registered under this act or an existing company as defined in clause 2. Above definition includes a term an existing company. Yes, above expression, above definition, above the company includes a term an existing company. Let us repeat. Company means a company formed and registered under this act, and also a company means an existing company as defined in clause 2. What is there in clause 2? Which carries the definition about existing company. Existing company means a company formed and registered under any of the previous company's laws. What are these previous company's laws? Let us understand. First, any act or acts relating to companies in force before the Indian Companies Act 1866 and repealed by that act. Second, the Indian Companies Act 1866. And third, the Indian Companies Act 1913. Fourth, the Registration of Transferred Companies Ordinance 1942. Let's repeat again. Existing company means a company formed and registered under any of the previous company's laws. What are these previous company's laws? First, any act or acts relating to companies in force before the Indian Companies Act 1866. Second, the Indian Companies Act 1866. One point we are missing earlier. Any act or acts relating to companies in force before the Indian Companies Act 1866 and repealed by that act, underlined, repealed by that act, that is the Companies Act 1866. Second previous Companies Law is the Indian Companies Act 1866. Third, the Indian Companies Act 1882. Fourth, the Indian Companies Act 1913. Fifth, the Registration of Transferred Companies Ordinance 1942. Sixth, any law corresponding to any of the acts or the ordinance aforesaid and in force in the merged territories or in a Part B states other than the state of Jammu and Kashmir or in any part thereof before the extension thereto of the Indian Companies Act 1913 and in the state of Jammu and Kashmir or in any part thereof before the commencement of the Jammu and Kashmir Act 1956 insofar as banking, insurance and financial corporations are concerned, and before the commencement of Central Laws Act 1968. There is another thing. The Portuguese Commercial Code insofar as it relates to Societas Anónimas. These are the previous company's laws we come across in the definition of existing company. Existing company means a company formed and registered under any of the previous company's laws. Let us move to clause 3 of subsection 1 of section 3. Very important definition we find here about private company. Private company means what? How is it defined? Private company means a company which has a minimum paid up capital of 1 lakh rupees or such higher paid up capital as may be prescribed. This condition is inserted by the Companies Amendment Act 2000 with effect from December 13, 2000. Again, first condition in the definition of private company. Private company means a company which has a minimum paid up capital of 1 lakh rupees or such a paid up capital as may be prescribed. Second, private company means by its articles restricts the right to transfer its shares if any. Third, private company means a company by its articles limits the number of its members to 50. It carries two provisos. Persons who are in the employment of the company are not included in the number 50, and also persons who, having been formally in the employment of the company, were members of the company while in the employment and have continued to be members after the employment ceased. Here, employees who continue or who are members of the company, they continue to be members even after ceasing the employment in the private company. These employees are not included here in the condition 50, limits the number of its members to 50. Let us go to fourth condition. Private company means a company by its articles prohibits any invitation to the public to subscribe for any shares of the company. It prohibits any invitation to the public to subscribe for any debentures of the company. Fifth, private company means a company by its articles prohibits any invitation, any acceptance of deposits from persons other than its members, other than its directors, other than their relatives. Other than their relatives means relatives of the members, relatives of the directors. It means private company can accept deposits from the members, from the directors, from the relatives of members, and from the relatives of directors, provided that where two or more persons hold one or more shares in a company jointly, they shall for the purposes of this definition be treated as a single member. We will try to understand the term jointly holding shares in this section itself after some time. Here we come across very interesting word, articles. Section 2 clause 2 says defines the term articles. Articles means the articles of association of a company as originally framed or as altered from time to time in pursuance of any previous company's law or of this act. This is how articles of association is defined. This is very important document. We always need to remember. A private company requests to have its own articles. What does it contain? It contains the restrictions, it contains the limitations, it contains the prohibitions which we come across a minute back while going through section 3 subsection 1 clause 3. Now we need to refer section 27 subsection 3 where it requires that articles must contain all requirements, all provisions specified in the definition. Let us see how it is saying as the provisions of section 27. Subsection 3 of section 27 says, in the case of a private company having a share capital, underline, in the case of a private company having a share capital, the article shall contain provisions relating to matters specified in subclause A, subclause B, and subclause C of clause 3 of subsection 1 of section 3. In the case of a company other than other private company, the article shall contain provisions relating to the matters specified in the set subclause B and C. This is how we are able to understand the requirement to see the articles of association of each private company, how the provisions contained in clause 3 of subsection 1 of section 3. From section 27 subsection 3 we are able to understand. Next, private company means a company which has a minimum paid up capital of 1 lakh rupees or such a paid up share capital as may be prescribed. This is we try to understand. Now let us go to next condition. Private company means a company by its articles restricts the right to transfer its shares. It restricts the right to transfer its shares, if any. It is here to give some control to the company over transferability. You may be thinking, are not shares transferable? Yes, they are transferable, prima facie. It is invalid as far as the restriction goes, which precludes a shareholder from transferring his shares. But it is felt that this restriction cannot be questioned. It is upheld that right of preemptions doesn't amount to a prohibition upon transferability. The restriction applies to all cases of shares that are concerned as far as the shares are concerned to private companies. Let us again understand. It is here to give some control to the company over transferability. Private company restricts the right to transfer its shares. You may be thinking, are not shares transferable? You are right, they are transferable prima facie. It is invalid as far as the restriction goes. I agree. Which precludes a shareholder from transferring his shares. But it is felt that this restriction cannot be questioned. It is upheld that the right of preemption doesn't amount to a prohibition upon transferability. The restriction applies to all classes of shares as far as the shares are concerned to private companies. Let us refer section 82, the nature of shares. The shares or other interest of any member in a company shall be movable property, underline, movable property, transferable in the manner provided by the articles of the company. Thus, these shares are transferable. We cannot prohibit them from transferability, but can subject to restrictions, underline. We cannot prohibit them from transferability, but we can subject them to restrictions. Next condition, let us try to understand. Private company means a company by its articles limits the number of its members to 50. Now this condition, let us understand. Now let us shift our focus to subclause B, where it says private company means a company by its articles limits the number of its members to 50. Here, it limits the number of its members to 50. It is required compulsorily as well as the company is concerned as a private company. Interesting point is that assume that there are 1000 employees now in a private company and each of them holds more than one share. In addition to this, there are another 800 retired employees. Each of them hold more than one share. Yes, it is still acceptable to remain as a private company in this situation. Holding jointly, this term let us understand. We come across in proviso to subclause B, where we come across the private company means a company which by its articles limits the number of its members to 50, not including. At the end, we will come across term holding jointly. Here we have seen an expression that where two or more persons hold one or more shares in a company jointly. Again, where two or more persons hold one or more shares in a company jointly, they shall, for the purposes of this definition, be treated as a single member. For the purposes of this definition, be treated as a single member. Otherwise, they are not treated so. This is treated so far as the definition is concerned to private companies. It is a strong feeling that they are not necessarily treated as a single member for other purposes, so long as the number of members doesn't exceed 50. There is another point we need to understand. Joint holders of shares can have their holdings split up and enable themselves to vote in other cases, but the private companies need to be conscious of maximum number of persons, that is 50. You may ask, what about if the debentures are issued by the private company? It can issue, but not to public. This we need to underline. Again, note that debenture holders may exceed 50. Let us see what it says. Private company means a company by its articles prohibits any invitation to the public to subscribe for any shares in the company, or it prohibits any invitation to the public to subscribe for any debentures of the company. The provision is clear that a private company can't issue any prospectus as it is prohibited by above condition. Now let us try to understand the definition of public company. We were understanding about private company, the conditions required, the definition, and the important point, restrictions, you may call them. Public company is defined in very simple terms. There are 3 points. Clause 4 says public company means a company which is not a private company. Underline. Public company means a company which is not a private company. Public company means a company which has a minimum paid up capital of 5 lakh rupees or such a higher paid up capital as may be prescribed. Public company means a company which is a private company, which is a subsidiary of a company which is not a private company. This is tricky to understand. Point 3. In simple terms, a private company which is a subsidiary of a public company is construed as not a private company but a public company. Let us repeat again. Public company means a company which is not a private company. Second point, public company means a company which has a minimum paid up capital of 5 lakh rupees or such a paid up capital as may be prescribed. This condition is inserted by the Companies Amendment Act 2000 with effect from December 13, 2000. Here, we need to recollect section 43A, where we come across deemed public company. Private company to become public company in certain cases. Section 43A. Here, a new subsection 11 is inserted. It says, nothing contained in this section shall apply on and after the commencement of the Companies Amendment Act 2000. This is how public company is defined. So we come across the definitions of 4 terms: company, an existing company, private company, and public company in subsection 1 of section 3. Now let us move ahead. You may recollect in the subsection 1 of section 3. In this act, unless the context otherwise requires, the expressions company, existing company, private company, and public company shall, subject to the provisions of subsection 2, have the meaning specified below. Underline. Subject to the provisions of subsection 2, all these terms shall have the meanings specified below. Subject to subsection 2. What is there in subsection 2? Let us understand. Unless the context otherwise requires, the following companies shall not be included within the scope of any of the expressions defined in clause 1 to clause 4 of subsection 1. And such companies shall be deemed for the purposes of this act to have been formed and registered outside India. The registered office whereof is in Burma, Aden, or Pakistan, and which immediately before the separation of that company from India was a company as defined in clause 1 of subsection 1. Let us go to subsection 3 of section 3. Subsection 3 and subsection 4 brings to our understanding about the minimum paid up capital in case of private company and public company. Let us go to subsection 3 of section 3. Every private company existing on the commencement of the Companies Amendment Act 2000. Again, every private company which is existing on the commencement of the Companies Amendment Act 2000 with a paid up capital of less than 1 lakh rupees, shall enhance its paid up capital to 1 lakh rupees. It requires to enhance its paid up capital within a period of 2 years from such commencement. Let us go to subsection 4. It says about public company. Subsection 3 was telling about private company. Now it is enabling us to understand about public company requirement as far as paid up capital is concerned. Every public company existing on the commencement of the Companies Amendment Act 2000 with a paid up capital of less than 5 lakh rupees shall enhance its paid up capital to 5 lakh rupees within a period of 2 years from such commencement. So when it comes to private company, it requires to enhance its paid up capital to 1 lakh rupees. If it is having less than paid 1 lakh rupees, its paid up capital. When it comes to public company, if it is having less than 5 lakh rupees as paid up capital, it requires to enhance its paid up share capital to 5 lakh rupees. This is what subsection 3 and subsection 4 of section 3 comes forward to explain us. Both are inserted by the Companies Amendment Act 2000 with effect from December 13, 2000. Let us go to subsection 5, where a private company or a public company fails to enhance its paid-up capital in the manner specified in subsection 3 or subsection 4, such company shall be deemed to be a defunct company. Underline. If it fails to enhance its paid-up capital as specified in subsection 3 or subsection 4, such company shall be deemed to be a defunct company within the meaning of section 560, and its name shall be struck off from the register by the registrar. Subsection 6, last subsection in section 3. A company registered under section 25 before or after the commencement of the Companies Amendment Act 2000 shall not be required to have a minimum paid-up capital specified in this section. This is when it comes to the companies registered under section 25. So these companies need not observe the requirement of minimum paid-up capital. Here in section 3 we are able to understand the terms company, existing company, private company and public company, and some important points on the minimum paid-up capital requirement in the case of private company and public company. If we did not observe the consequences also we found in subsection 5. In subsection 6 we are able to understand that minimum paid-up capital requirements mentioned in subsection 3 and subsection 4 are not applicable to the companies registered under section 25. Thank you, all of you.